Okay, welcome. This is a CPA April 2022 paper. We'll be tackling question 7. Question 7. With reference to negotiable instruments, explain 4 parties to a bill of exchange. With reference to negotiable instruments, explain 4 parties to a bill of exchange. Now, the most common parties we have 3 most common parties. We have the drawer, then we have the drawee, then we have the payee. These are the most common parties. So we're also going to look at the holder, and then we have the acceptor, then endorser, and we also have the endorsee. All these are active parties when we talk about the bill of exchange. So you can pick any 4, but these are the active parties in a bill of exchange. So who is the drawer? The drawer is the party. This is the party that issues the bill of exchange, or the parties that writes a check in favor of somebody. So this is the party who writes a check, the party who is supposed to pay. So the drawer is the party who issues the bill of exchange. And who is he issuing the bill of exchange to? He is issuing the bill of exchange in favor of the payee. So the payee is the one who will benefit from the bill of exchange issued by the drawer. So the payee is also called the beneficiary. The payee also called the beneficiary, and it is the party to whom the bill of exchange is payable. Bill of exchange is payable. It is the party to whom the bill of exchange is payable. The party to whom the bill of exchange is payable. So this is the party who will actually benefit from the bill of exchange. It's like somebody gives you a check. So the one who receives the check, who will get the value of the check, is the payee. And then the one who has written that check or issued the check will be the drawer. The one who will actualize that check into cash will be the drawee. So the drawee, in most cases, if you are talking about a check, the drawee becomes the bank. So this is the party to which the order to pay is sent. Party to which the order to pay is sent. And in most cases, he will be the acceptor. So the drawee will be the person who accepts the bill. Acceptor is this person who accepts the bill. And normally he accepts the bill from the payee. The payee receives the bill from the drawer, then presents it to the drawee for payment. So when the drawee accepts that bill of exchange, he becomes the acceptor. So in most cases, the drawee is again the acceptor. Once he accepts the bill of exchange, he becomes the acceptor. So drawer does the check or writes the check, and he will hand over the check to the payee or the holder. There's a possibility that he can also hand over the check to the holder. The holder is the person who is in possession of the bill, the person who is in possession of the bill. The person who is in possession of the bill after it has been drawn. After it has been drawn. So we've said it's the drawer who will do the bill of exchange or the check. Then either it will be received by the payee or the holder. It can be received by either the payee or the holder. The holder is the person who is in possession of the bill after it has been drawn. So he can be in possession, but it doesn't mean that he will be the beneficiary. Maybe he's just receiving on behalf of the payee. So either the payee or the holder will receive the bill from the drawer. Then they will present that bill to who? To the drawee, which if you are talking about a check, then the drawee could be the bank. The bank is the party to which the order to pay is sent. It is the bank that converts that check or bill into money. So either the payee or the holder will present the bill to the drawee, and when the drawee accepts that bill of exchange, he becomes an acceptor. And then that explains the 5. Then we have 2 remaining. We have the endorsee and the endorser. The endorser is the party or the person, and it can either be, in most cases, the holder. It can be either the drawer or the holder who endorses. Endorsing is just signing. Who endorses the bill to any other. By signing at the back. That is the endorser. He signs at the back and basically passes it over to another person who will now be the endorsee. The endorsee will be the person in whose favor the bill is endorsed. The bill is endorsed. So the endorsee, the person in whose favor the bill is endorsed. Endorser is this person who will now endorse the bill to another one, who in most cases will be the endorsee, and he will simply sign at the back of the bill of exchange or the check. But the most common ones are these 5. So this question is interested in only 4 parties, the bill of exchange. So you can pick any of these. These are 8. Just pick any of any 4 from the 8 and you'll be good to go. Then the next question, with reference to the administrative law, state 6 principles of with reference to the administrative law, state 6 principles of natural justice. 6 principles of natural justice. So natural justice has everything to do with the reasonableness, has everything to do with the fairness and the justice system that will be accorded to each and everybody in equal measures. That all of us should be the same in the eyes of law. That is the premises against which this maxim of natural justice is premised. That there should be reasonableness, there should be fairness, and there should be justice in the dispensation of law, so as to ensure equity and equality at the end of it all. There should be no any one person who is favored than the other. The law should be able to treat each and everybody equally. Now, when we talk about the 6 principles of natural justice, the first one is everybody should be accorded a fair hearing so that he can basically explain his situation well, to be heard, so that from the hearing a fair judgment can result. So fair hearing is one of the principles of natural justice. The other principle of natural justice is the absence of bias. Absence of bias, that everybody should be heard in the absence of bias. Biasness is being it's about favorism or appearing to lean on one side, so that at the end of the day the judgment becomes it becomes a judgment that is based or pegged on interests. So there should be no or there should be absence of bias in the process of ruling for this maxim of natural justice to apply. Then there should always be adequate notice to enable preparation on the part of each of the aggrieved parties, or each of the parties who are interested or are involved in that particular suit. So there always should be an adequate notice to enable maximum preparation towards the presentations that will take place in the hearing. Then the other principle also is the possibility of legal representation. If there is need for legal representation, then this person should be legally represented, and that also comes in as one of the key items in the principle in the maxim of natural justice. Right to know the adverse evidence. Right to know adverse evidence against any of the involved parties is also one of the key principles, and basically this is about information. So the other party should have access to information which possibly will be used in the process of judgment. And then reasonable there should be the participant should be given clear reasons as to how the judgment was arrived at, as to how the judgment was arrived at, as to how the judgment was arrived at, as to how the judgment was arrived at. That can also come in as one of the key principles of natural justice. It's all about involving all the parties and making sure that there's no room for biasness, there's no room for unfairness, there's no room for maybe one of the parties' rights being infringed on. Right to present cases and evidence. I think that one will come under fair hearing. And maybe if there's anything, let me check. Right for the cross-examination, also a very important principle. Cross-examination, a very important principle on natural justice, because it can help elicit some more information which otherwise could not have been elicited. So the major principles of natural justice will be this: the principle of fair hearing, the absence of bias in decision making, and adequate notice, though these others can also apply. The examiner was interested in 6 principles of natural justice. The most obvious ones are 3, but we can always top up with these others. But the most obvious principles of justice are fair hearing, absence of bias, and adequate notice sent to the parties involved. These others can also help to make it 6. Then highlight 3 principles that will guide the court in determining the presence of bias in the decision of an administrative body. 3 principles that will guide the court in determining the presence of bias. So number 1, we have the first principle is that no man can be a judge in his own case. No man can be a judge in his own case. This is a very important principle that will guide the court in determining the presence of bias. Chances are very high that if you become a judge, or possibly your kin is a judge, the chances are very high that there will be presence of bias. So this basically means that you cannot be a judge in your own case, or your kin may not be a judge in your own case, because there will be elements of favorism. And then we have justice. Second one, justice should not only be done, justice should not only be done, but it should manifestly and undoubtedly be seen to be done. So it's not just about dispensing justice, but it should go beyond the just dispensation of justice and manifest or undoubtedly be seen to have been done. So that basically makes it a key principle when we are talking about convincing the other party that there is no biasness in the decision. So as much as, yes, we are trying to be fair, but it should also be seen that you have put everything in place in favor of fairness in the judgment that you are about to dispense. Then number 3, justice should be, or rather the judges who are delivering the judgment should be above suspicion. So anytime a judge is suspected, then that means that there will be issues on biasness. So for issues of biasness to disappear completely, the judges must be seen not to be suspicious in any way. They must be above suspicion. And this make the 3 key principles that will guide the court in determining the presence of bias. The general rule is that anybody who has an interest in the case before him, whether monetary or in form of the subject matter, he should not preside over that case. And these are some of the principles that will be used to determine whether he has an interest in the case or not. So, thank you. Let's meet in the next question.